Hi guys, this is going to be the second part of the 10 rules for ethics for paralegals. Obviously, we've gone through half of them, so we're going to pick up right where we left off on the last video. This is going to be rule number 6, and it's going to be a pop quiz. And to set it up a little bit, imagine this scenario, and some of you may be familiar with this because you may already be working at law offices or have some experience. But basically, a client comes in, they have some kind of a claim, and they go ahead and bring a bunch of documents, and basically they hire the law firm to help them in whatever it could be. It could be any kind of a legal matter, wills or an accident, a criminal matter, anything. Over time, you work on the case, you collect more documents, maybe you prepare information motions and things like that, and they all go into the file. A few months in, though, the client becomes dissatisfied with the work of your firm, so they decide to hire another lawyer. It happens. You know, people are free to hire who they want, just like you're free to go to a different doctor, they're free to go to a different lawyer. However, the client still owes money to the law firm you're working at. And so what winds up happening is the new lawyer or maybe the client themselves come back and say, hey, look, I want my file. I want the file that you've been working on. I want the documents that I brought in and gave to you. You know, it could be things like birth certificates. It could be accident reports, anything like that. And they say, I also want everything else that you have, you obtained it during the course of the representation. Now, the big issue here is the client still owes fees to the law firm. Let's say that they had agreed to pay $10,000, but they've only paid $3,000, which was the original retainer, for example. The law firm then says, okay, we're not going to give you the file until you pay us the money, okay? And that's really the pop quiz. Can a law firm hold a client file hostage for payment of the fees? It happens. I've seen this happen. I've had this situation. The answer is no, you cannot. Now, one of the things that goes on is, I know some of you who work in law firms might say, well, wait a minute, I know that's wrong. I've had students sit in class there and be like, no, Mr. Ogin, you're wrong about that. We do it all the time. You may do it, and I know attorneys that do it, but it's unethical to do it. And the reason it goes back to is twofold, according to the state bar. The first is that the file actually belongs to the client. It does not belong to the law firm. That is the way that the state bar looks at it. So basically, when you tell someone, look, I'm not giving you the file until you pay me your fees, you're basically withholding property that doesn't belong to you, to the law firm, basically. The second issue, which is a more practical issue, but one that the state bar also highlights, is that when you hold on to a file, you may be hurting the client's case. Some claim, for example, some cases are time sensitive. You know, you need to file things within a certain period of time, or else the person will lose procedurally. In other words, because they fail to file it in time, they can no longer file. So imagine like a statute of limitations, where basically the client forgot, didn't file the lawsuit in time, and then the court says, well, sorry, you had a good suit, you had a good claim in this car accident or whatever, but you waited too long to file. By holding the file hostage, you're actually impacting negatively the client's case. And so the state bar says you cannot do that. Just so you know, and like I said, I've had students who said, no, that's wrong, Mr. Ogin. They can. There is the rule 1.14b of the state bar ethics, require that all property that a law firm holds for a client has to be turned over, including the file, even if the client still owes money. If not doing so will hurt the client's interest, and most of the time it will hurt the client's interest because the client is trying to move on with the case. Okay, it could be a little bit different if the case is closed and there's no other interest involved, but the general rule should be just turn the file over and avoid that kind of a problem. So be aware that if you hold on to the file, you're going to have those issues. The other issue that comes up here as well is if the client requests the whole file, it includes everything, including work product. That is something, again, that some attorneys sometimes miss. In fact, I myself wasn't even clear on that rule until I actually wound up researching it for this class many years ago. But the reality is the state bar says everything. If the client says, I want everything in the file, including motions that were prepared, memorandums, it can be the notes. Remember rule number 1, documenting, keeping that little log of activity, they can request that. That has to be turned over. So where it's important to understand is beware of what you write in a client's file. Some people like to write derogatory things in people's files. Okay, so they'll write, oh, May 31st, a whole client called again, that kind of stuff. Understand, if you're putting that in a file, okay, and the client demands it at some point in the future, you'll have to turn that over. And if the client is making a claim or a grievance against the attorney or the firm saying, hey, look, they were prejudiced against me, they were hurting my case, that's evidence that basically that's what was going on, because the client, or excuse me, the law firm or the lawyer or someone in the law firm didn't think very highly of the client. So this again goes to the idea of be careful what you're writing, be professional, don't make derogatory terms, don't write things in there, about people's appearances or what you think about them. Keep that out because the client may be able to get it. And again, this is a rule, guys, that a lot of times attorneys forget. I've seen it happen several times. I've had to, and I'm just telling you, I've had to tell lawyers, look, I need this file, I need you to turn it over, because they themselves aren't aware of this rule and they want to hold fees. Now, two other things, they can still try to get the fee from the client, okay? This doesn't mean that they are, that they can't get the fee. They can still try to get the fee. And they can also charge a reasonable charge to actually copy the file. So, it can be like 25 cents a page or whatever it can. The law firm can do that. Now, of course, they can't hold it hostage until they pay the copying fees either. They have to turn over the file and say, hey, you owe us for the copies. But it's an important rule to understand, because sometimes a lot of people, including a lot of attorneys, sometimes don't really understand it. Now, another number 7 is going to be the, let me just bring it up, is going to be the unauthorized practice of law. This is going to have to do with the idea that basically, let me just put this up. This is going to be the idea that basically you cannot hold yourself out as a lawyer. Where this comes up, guys, is a lot of times, especially if you've worked for a very long time, you'll become an expert in a particular area of the law. There's nothing wrong with that. You'll be able to, know good cases, bad cases. You'll be able to tell what type of motions should be filed, things of that nature. That comes with practice. Good, smart paralegals figure that out. The thing is, you're still not an attorney, okay? You cannot give out legal advice, no matter how experienced you get in a certain area. So let's say you do wills. That doesn't mean you can start writing wills for people, especially for money. That will get you in trouble. And in fact, it's a crime in the state of Texas. It's called barratry. Okay. Now, let's say you get really good at writing wills. You can write wills for yourself. Okay. You can write contracts. This is a contracts class. In this class, you're going to learn how to write contracts. You can write contracts for yourself all day long. That's not an issue. What is an issue is if you go and say, hey, I'm going to start writing contracts for other people, especially if you're doing it for money. That is illegal. Same thing. Oh, I'm going to go and review other people's contracts. That is not allowed either. That is unethical behavior. Now, again, you can write your own contracts for yourself. You can also review contracts for yourself. In other words, if someone presents you a contract and you look it over, I certainly hope you'll review it, because part of what I'm going to be teaching you this semester is how to look at those contracts. What should you look for? Traps, things you should be aware of, that kind of thing we're going to be covering. But you cannot actually go out and give legal advice or do anything of that nature. The third thing you cannot do is you cannot be a notario. Okay. Now, what is a notario? If you're not familiar with it, okay, this concept comes from Mexico and Latin America. You may or may not be familiar with it, depending on how much you know. But basically, a notario in Mexico is kind of like a paralegal, but not exactly. A notario in Mexico is a position in which a person has taken some classes and passed a written exam and can actually prepare documents like contracts, like wills for people. They can't go to court. They're really not advocates in that sense, but they can prepare those documents. So that type of designation within the legal system does not exist in the United States, okay? It does not exist in the United States. However, there are people who confuse notario with notary public. We've all heard of notary publics. Notary publics are people who basically acknowledged signed documents. In other words, the notary public is someone who verifies that the person signing a document is actually that person. To be a notary public, and some of you may be notary publics, you do not need to go to any kind of school. You basically pay a fee to the state, and the state sends you, the state of Texas will send you a little stamp and a little booklet where you keep a log of everything. That's all. But there are people who take advantage of the fact that, oh, there's a notary public. I'm going to be a notary public in the state of Texas, but also I'm going to tell people that, oh, I'm a notario. And people, especially people from Latin America, think, oh, you can prepare legal documents. This is really big in the area of immigration law. A lot of people will go into notarios thinking that they can prepare their immigration documents for them. Unfortunately, the notarios don't know what they're doing. That's from my own experience. And the big lure is they charge a lot less than what a lawyer charges. The problem is, and I had these cases when I was doing immigration law, it would be a mess to fix, okay? So kind of don't do it. Stay away from that whole area of, oh, I'm a lawyer, or I'm going to give legal advice. I recognize that you may become an expert, but you have to really, really be careful about not telling people what to do in their cases, be giving that kind of a legal advice, because it's something that could get you in trouble, and it could be bad legal advice for them. Number 8, you cannot solicit clients. This kind of ties in with rule number 7. Solicitation is going to a client and trying to get their, not a client, but going to a person trying to get their case. It's what you might hear, it's called ambulance chasing. So imagine the scenario where I hear someone gets in an accident and I run off to the hospital to meet with them, okay? You know, I walk into the hospital and basically I wind up telling the guy's mom, hey, you know, I'm here, don't worry about it. We're gonna be able to help out your son. Just sign here on the dotted line. That's solicitation, completely unethical. I can get into all sorts of trouble for doing it. Where I've seen people get into trouble, the paralegal decides to solicit. So instead of the lawyer going into the hospital, the paralegal goes in. You can't do that, okay? You cannot do that. And where I've seen it taken a step further is there's some paralegals who, again, because they're smart and they know a lot, they decide to kind of create this little gimmick. And what they do is they go to a lawyer and they say, hey, look, you do personal injury. I know you can't go and solicit clients at the hospital, but I'll go for you. And here's what we're going to do. We're going to split the fees. For every client that I bring you, that's how you'll pay me. Instead of paying me a salary, instead of paying me a wage, what we're going to do is you're going to cut me a portion of whatever it is that we win. That is unethical. Attorneys cannot share fees with non-attorneys. And it is also unethical for a paralegal to go solicit clients. So you shouldn't be doing that. If an attorney is asking you to do that, understand it's unethical, but where I actually see it more often is where these very experienced paralegals decide, hey, I'm gonna try to make myself some money by going out and soliciting clients. You can't do that. The attorney will get into trouble, and so will the paralegal. Rule number 9, you cannot be deceptive, okay? Where this comes up is where you want to look at a case and you decide that the person, well, you find out the person's on social media, okay? And you want to see if you can get some information from them. And you decide well, instead of, just reaching out to me as them as the law firm or whatever, you decide to create a fake Facebook or a fake Instagram or whatever page, fake name, fake profile picture, everything, and you try to friend them. So maybe they have a Facebook page, but it's not public. So you have to be friends with them to see their information. And sometimes, social media is a great tool to investigate, a great tool. People put up all sorts of crazy stuff up on social media. I've used it in cases, but you cannot lie about who you are. In other words, you can't create fake profiles. You can't create fake identities to try to get information from people. The State Bar has said that's deceptive and it can't be done. In a similar vein, if you know that the other person is represented by an attorney on the legal matter, let's say, again, it's a personal injury, someone fell in the store of this man and the store is being sued, the man owns the store. You can't be reaching out to him knowing if you know that he has a lawyer already representing him on that. You have to go through the lawyer, okay? And again, if you witnesses, that sort of thing, if you know that they're represented by a lawyer, you have to go through the attorney. You can't go on your own. The last rule, and this will wrap up this section. This is why it's important, guys. And I kind of talked a little bit about it before, but lawyers must properly supervise their paralegals. I have a law license. If I every year, I have to get it renewed, and I can get it taken away from me if I behave unethically. And if the paralegal, the investigator, the legal secretary behave unethically, they can come after me for that. Because one of my ethical responsibilities is to make sure that all paralegals are being properly supervised. Okay. Now, in that regard, one of the other things to be aware of is, online, here on this is the State Bar of Texas homepage. Okay. Right here, you can get information on attorneys. Okay. For example, find a lawyer for the public. So you just click on here, and I already had filled out the name of an attorney. This gentleman was a longtime attorney here in El Paso who was convicted of a federal crime. And you hit submit, and you look up the attorney, and you'll notice right here there's like a little status thing. Okay. Eligible to practice, not eligible, non-practicing. Mr. Jones, unfortunately, is not eligible to practice. After he was convicted, he did lose his law license. Okay. So obviously, if this gentleman were to come to you and say, hey, I'm an attorney, I can help you, you would know that, in fact, he is not eligible to practice. He is, in fact, committing an ethical violation by saying he's an attorney. You can look up lawyers like this. Don't look me up. If you want to, you can look me up. But you can look up anyone. The State Bar of Texas page is also very handy because one of the other things that I see, students will come to me and they'll say, hey, Mr. Holguin, my brother hired, whoever, this lawyer, John Smith. Is he a good lawyer? I don't know all the lawyers in town. The name doesn't sound familiar. So I say, no, I'm not sure, but let me ask around. I start asking around, and no one's ever heard of John Smith. No one can tell me anything. Still, maybe he's new to town, and that doesn't mean he's bad. I will go to the State Bar, that same page I just showed you, punch in the name. A lot of times, guys, the name doesn't come up. The reason it doesn't come up is because, again, one of the things that happens is sometimes people want to hire a lawyer, they call, make an appointment, they go into the law office, or nowadays maybe they do a Zoom meeting, and the person that they see is not actually an attorney. Instead, the person that they're seeing is a paralegal or an investigator. And they have this interaction with this person thinking, oh, this is my lawyer, but in reality, it isn't. It's basically a member of the legal staff. Now, as long as the person hasn't said, oh, I'm a lawyer, or I'm going to be your lawyer, that's okay. But it's something that occurs. And I always tell the student, look, my best guess is that this, we looked him up, we couldn't find him, is that he's probably a paralegal. Next time that your brother or whoever meets with him, or you meet with him, ask him, so who is the attorney? And can I talk to them about my case? You're entitled to talk to the lawyer about your case. And I always would say, before you make any critical decisions, always have that meeting with the attorney. Don't just meet with a paralegal. Don't meet with just the investigator. You should always have a meeting with the attorney themselves, because they'll be able to more accurately tell you what's going on with the case and more accurately answer your questions. I'm going to wrap up this one, guys. We're going to be talking in the next section about business ethics, and that's going to be something that we'll be also able to refer to the book. I'll see you in the next video.